Good evening. Welcome to KiniNews. I'm your host, Camelia. Petronas has responded to reports on the seizure of its assets overseas. The company said it viewed the action as baseless and will defend its legal position on the matter.
Petronas has confirmed that two of its overseas subsidiaries mentioned in a report yesterday were served with seizure orders on 11 July 2022. In a statement, they said that the two subsidiaries mentioned in the report, Petronas Azerbaijan, Shah Deniz, and Petronas South Caucasus, had previously divested its entire assets in the Republic of Azerbaijan, and the proceeds from the exercise had been duly repatriated. Petronas added that it viewed the action of alleged seizure of its assets as baseless and is working vigorously to defend its legal position on this matter. Yesterday, London-based Financial Times reported that the heirs of the purported Sulu Sultanate, who are claiming over 62 billion ringgit from Malaysia, had seized two Luxembourg-incorporated subsidiaries of Petronas. According to the report, lawyers of the claimants have seized Petronas Azerbaijan, and Petronas South Caucasus reportedly worth $2 billion. The lawyer said bailiffs in Luxembourg seized the holding companies on behalf of their clients on Monday. This came after an arbitration process was initiated in response to Malaysia cutting off the annual lease payments of 5,300 ringgit to the Sulu Sultanate in 2013. Malaysia did not participate in the arbitration process in France, arguing that the dispute between Malaysia and the claimants was not a commercial contract and thus not subject to arbitration.
Meanwhile, several MPs have called on Prime Minister Ismail Sabri to respond to the issue. A DAP lawmaker said the news has put Malaysia in the spotlight again for the wrong reasons. A DAP lawmaker has called on Prime Minister Ismail Sabri to explain to the nation how national assets under Petronas were seized in Luxembourg by the heirs of the purported Sulu Sultanate. In a statement today, Kapong MP Lim Lip Eng said the news had put Malaysia in the spotlight again for the wrong reasons. He was referring to the London-based Financial Times report that said that lawyers of the claimants had seized Petronas Azerbaijan and Petronas South Caucasus, reportedly worth $2 billion. According to Lim, Malaysia was now an international embarrassment again after the much-publicized 1MDB financial fraud. He said that Ismail Sabri is duty-bound to inform the public of the steps to be undertaken by the government to safeguard other assets overseas from being seized. Lim added that investors and the financial markets will also lose confidence in the country if Ismail is unable to provide any sensible explanation. This is as the amount claimed by the Sulu heirs amounted to a total of 62.59 billion ringgit from Malaysia. The woman behind the controversial stand-up routine at a comedy club has been charged with causing disharmony among the Muslim community.
A woman who performed a controversial act at a comedy club in Taman Tun Dr. Ismail has claimed trial to a charge of insulting Islam. Siti Nuramira Abdullah was composed and pleaded not guilty when she was charged at the Kuala Lumpur Sessions Court this morning. She was charged under Section 298A of the Penal Code for causing disharmony among the Muslim community with her act. Section 298A deals with the offense of causing disharmony, disunity, enmity, hatred, or ill will on grounds of religion between persons or groups of persons professing the same or different religions. She can be jailed for a minimum of 2 years and not more than 5 years if found guilty. The court set bail at 20,000 ringgit with one surety, ordering Siti Nuramira to report to the Bricksfield police station once a month. The judge also ordered her to surrender her passport to the court and not to make online comments over the case. The court set August 18 for mention of the case. Previously, a video of the incident at the Crack House Comedy Club in TTDI had gone viral on social media. The police had detained Siti Nuramira on July 10th, and she has been in remand until today.
The anti-hopping bill, which has been delayed since March, could be enforced by September. This is according to de facto Law Minister Wan Junaidi Tuanku Jaafar. The bill aimed at restricting MPs from switching parties could be gazetted by late August or in September. This is according to Minister in the Prime Minister's Department Wan Junaidi Tuanku Jaafar. He revealed this in a statement today after outlining the latest timeline for the bill. According to Wan Junaidi, the bill will be tabled on July 18th, and the Select Committee, which reviewed the bill, has proposed July 27th and 28th for the debate. He said the Legal Affairs Division of the Prime Minister's Department and the Attorney General's chambers will hold briefings for government and opposition MPs before the debate on July 25th and 26th. He added that briefings for Dewan Negara members will be on August 8th and the debates will start on August 9th. If the passage of the law goes through both the lower and upper houses smoothly, Wan Junaidi said the government can seek assent from the Yang di-Pertuan Agong between August 11th and 26th before finally gazetting the bill between August 28th and September 2nd. Still on the anti-hopping bill, Azalina said the bill is now out of the cabinet's hands and they are in no position to block it. The cabinet is in no position to block the anti-hopping bill, said Pengerang MP Azalina Othman Said. She told Malaysia Kini that as the bill was already going through the legislative process and was under the purview of a select committee, it was out of the cabinet's hand. Azalina, who is a member of the select committee, explained that the cabinet's role was limited to having the law minister chair the select committee and pose questions to the select committee where necessary. She said they are not in a position to direct or instruct the select committee at any point. Azalina added that Prime Minister Ismail Sabri should be commended for initiating the select committee, which had allowed for the bipartisan lawmaking. She said having a small group of MPs to scrutinize the bills provided the necessary conditions for a conducive and constructive discussion. Azalina said this was as all those involved will have a sense of ownership in the drafting process. She said bipartisan lawmaking was more effective in bringing changes and reforms and described this as the way forward. Azalina added that the public can expect a bill that has been very thoroughly scrutinized and drafted to be tabled at the House on July 18th. The Registrar of Societies will decide on UMNO's constitutional amendment soon. However, a Bersatu man has questioned the legitimacy of the UMNO leadership to pursue the amendment. Johor Bersatu leader Bajrul Hisham Shaharin has questioned the legitimacy of the UMNO leadership with their move to amend their party constitution. This comes as the deadline draws nearer for the Registrar of Societies to decide on UMNO's constitutional amendment to delay party polls. In a post on Facebook, Bajrul said UMNO already had a caretaker leadership when an emergency general meeting was held to amend the party constitution. He said it was different from MCA, which had sought similar constitutional amendments 3 years ago. Bajrul argued that the MCA leadership was still serving their term, unlike UMNO, whose leadership term had expired on June 30 last year. He added that UMNO's leadership is only a caretaker one, and according to Clause 9.3 of UMNO's constitution, the party's Supreme Council must be chosen every 3 years. Previously, UMNO Secretary-General Ahmad Maslan had disputed suggestions that the present leadership was a caretaker. He said this was as the ROS had on August 30 last year approved UMNO's decision to postpone its polls by 18 months. Ahmad said this meant that the present UMNO leadership's tenure had been extended until December 29 this year, and they are free to make policy decisions. The ROS has until July 16th to respond to UMNO's constitutional amendment. Past Deputy President Tuan Ibrahim Tuan Man has explained why Perikatan Nasional had decided to change their logo for the next general elections.
The proposal by Perikatan Nasional to use a new logo and color in the 15th general election is to avoid confusion between PN and Barisan Nasional. This is according to past Deputy President Tuan Ibrahim Tuan Man. Speaking to reporters yesterday evening, he said the top leadership of PN discussed the proposal after the Melaka and Johor state elections showed that some of its supporters were confused between the PN and BN colors. He added that PN would also look into the possibility of changing to a color that is different from those of BN and other parties in the next general election. He said this when asked to comment on PN chairperson Muhyiddin Yassin's statement that PN was planning to introduce a new logo for GE15. Muhyiddin had said that PAS had informed PN that it wanted a more suitable logo for the coalition, and this was being worked out by Secretary General Hamzah Zainuddin.
And that is all from me today. For more stories, you can go to KiniTV.com. You can also follow us on Instagram, Twitter, YouTube, and Facebook for the latest news updates. If you'd like to support independent media, do consider subscribing to MalaysiaKini.com. I'm Camelia. Thanks for watching.